Well, now that I have received a text message or email from a representative from pretty much every company in the industry asking about the new surcharge rule and what the impacts might be for dual pricing and compliance and all these other things, I decided to make one video that is going to give you everything that you need to know right now about Visa compliance, dual pricing, surcharging, and cash discounting. Before we dive in, I'm not an attorney. This is not legal advice. This is not professional advice. These are my opinions on these topics. Visa recently came out with a memo that said that they were taking the cap on compliant surcharging from 4% to 3%, and it included a few other things about how they were getting rid of the requirement to register with the card brands and some other things. But the big news is that reduction from 4% to 3%. With compliant surcharging, this is where we're adding a fee to credit card transactions, but we're not allowed to add a fee to debit card transactions. And in the past, the limit was at 4%. As of April 15th, 2023, that number is going to be 3%. In addition to this news, at the same time, Visa seems to be dramatically ratcheting up their compliance actions. So I wanted to give you an update on that as well, and a few other things before we make it practical of what you can do. First of all, for those ISOs and agents that are still selling non-cash adjustment, service fee, or some other line item on the receipt to gross up or increase the cash price, Visa is coming after those merchants very strongly. What you may not understand is that behind the scenes, Visa had a memo several months back to all of the banks, the sponsor banks, requiring them to submit information on each ISO that's registered with them. If those ISOs are offering any type of differential pricing, cash discounting, surcharging, dual pricing, etc. And then Visa also apparently, I've heard this from 4 different people. Visa apparently has contracted with a company for their secret shoppers, their mystery shoppers. Visa does have a bit of an army out there now that's able to go out, and so they got all this information, and Visa knows who the merchants are and those, which sponsor bank and ISO those merchants are with. So they have apparently been targeting and going after certain merchants based on the program that they may be using to validate that their pricing is compliant with Visa rules. Now, the other thing that's an important shift here is the fees. And this is super important for agents especially to understand, because many times the agents look at all of this and say, why doesn't my ISO just stand up to Visa? Why doesn't the acquiring bank just stand up to Visa and say, no, we are compliant, and this program is, our merchants' free speech rights or whatever. And the reason is fees and fines. I have personally spoken with dozens of ISOs who have paid either a $5,000 fine or a $10,000 fine for one particular merchant who Visa determined was not compliant with their rules. Now, you would think, okay, that must be that they're doing non-cash adjustment, and you would be right. But there are also now cases that we've seen with 3 companies I've talked to now where they have actually received a notice of an impending fine or actually been fined for a merchant that was doing dual pricing but had not changed the pricing on the shelf or on the menu to reflect that dual price. Now, one of the documents, if we go way back to 2010, one of the documents that started all of this was the Durbin Amendment. So I thought it might be beneficial for me to read one little section of that, so I grabbed my phone to read that to you. In general, a payment card network, that would be Visa, MasterCard, etc., shall not directly or through any agent, processor, or licensed member of the network by contract, meaning they can't use their contract for this, by contract, requirement, condition, penalty, like a fine, or otherwise inhibit the ability of any person to provide a discount or in-kind incentive for payment by the use of cash, check, debit card, or credit card. And it goes on to say a couple of other conditions. Now, this law very clearly lays out that the card brands are not allowed to require or use their contract terms to keep a merchant from providing a discount or an in-kind incentive for people to use a certain form of payment. However, the way that Visa has historically gotten around this particular law is that there is another little section in the agreement that defines the word discount. It says, The term discount means a reduction made from the price that customers are informed is the regular price and does not include any means of increasing the price that customers are informed is the regular price. So Visa has used that language to say, okay, that does protect a true cash discount program, but it does not have anything to do with surcharging. And now it may not have anything to do with dual pricing if the shelf and the menu price are not changed, because we are informing the customer of a regular price, and then that regular price is going to increase when they get to the counter and pay with a credit card. Now, I have argued many times that the spirit of that law, and especially the wording about the in-kind incentive, means that the merchant can inform the customer of the regular price without having two prices on the shelf or the menu. And I believe that that would hold up in court. But again, I'm not an attorney, and apparently nobody is willing to go after Visa for these potential violations of the Durbin Amendment. For those of you that are newer to this topic, let me quickly define three things. What is cash discounting? Cash discounting is when you raise the regular price and you offer a discount from the regular price. What is surcharging? Well, compliant surcharging in the US is where we can add a fee not to exceed 3% as of April 15th. We can add a fee to credit card transactions, but we may not add a fee to debit card transactions, that's signature debit or PIN debit. Dual pricing is where we have a cash price and a card price. The card brands have specifically listed fuel stations, gas stations, as a really good example of dual pricing, where they have the cash and the card price listed there for customers so they can see what the price is going to be depending on the form of payment that they use. Now, one final topic that is crucially important to understand is the scope of compliance, okay? Who is responsible for enforcing these Visa rules and regulations? Visa is now saying, hey, the merchant, if they're going to do dual pricing, they have to have the price on the menu and the shelf. Okay, Visa, if you want to go ahead and enforce that, knock yourself out. But who is responsible for enforcing that? If the party responsible for enforcing it is the sponsor bank and by extension the acquirer, the processor, the ISO, we have a bit of a problem because it's very difficult, actually impossible, for these companies to monitor the way that a merchant is pricing items in a physical way at their location. Now, we can crawl a website or do that sort of thing, but it's, in my opinion, unreasonable to ask acquirers and ISOs to monitor what's on the shelf or the menu at each of their thousands of merchant locations, because those things can change on a regular basis. Since we're not in the business of printing menus or anything like that, that's going to be troublesome. So what do we do about this change in the market? Okay, well, there's two paths that I think we need to go down as an industry. There's the long-term plan and there's the short-term plan. So let's start long-term. Long-term plan, if we want to protect the profitability of these programs, is that we need to start thinking a little bit bigger, and we need to understand that Visa is not a government agency. And by the way, Visa has quite a few enemies right now and quite a few problems of their own. So if our industry is going to stand up to Visa and begin to communicate as a group to Visa about the concerns that we have in terms of the compliance actions that they're taking and the burden of compliance that they're putting on our industry specifically, that I believe will begin to push things in the right direction. I also believe we need to look at regulation, legislation, and even enforcement actions where we're reaching out to various government agencies to say, hey, can we take a look at what Visa is doing here relative to the Durbin Amendment and other items here, other precedents, court precedents, things of that nature. Where do they stand in this? And let's kind of take the temperature of different organizations. So again, if you're watching this video, that may not be something that you can do, but it's something that the company that you work for, or maybe their processor or acquirer. And so that's something that I'm starting to work on behind the scenes a little bit, is to kind of talk to the people in the industry to see what can we do about this, right? Long term. I should also say that I still believe firmly that long term, meaning 5 years from now, this problem will not exist, because this will eventually go to court in a class action or some other kind of court action. We've seen it in many other countries, and the courts just don't care about this issue. At the end of the day, they're going to protect the free speech rights of the merchants, and they are going to side with the Durbin Amendment and the spirit of that law and say, look, if merchants are doing something on the shelf or the menu, that's up to the state attorney general's office to enforce consumer protection laws and consumer disclosure laws. It's not up to a private company to monitor what's on the shelf or the menu of a privately held company. Unfortunately, we have to deal with the short-term reality of now, and the reality of now is these big companies in our industry are not taking action. They are not standing up to Visa at all, and as a result of that, no one is calling Visa's bluff, if it is a bluff in this area. So everyone is terrified of the fines that are coming down the line, and there's talk of, $1 million fines and things like that are already, there's conversations about this for ISOs that are repeat offenders, things like that. So this is serious money. It's going to cause a lot of ripples and issues in the industry. So what do we do about it? Number one, stop adding a line item to the receipt. Now, if you want to do a compliant surcharge program and add 3% to credit card transactions and not add anything to debit, more power to you. But if you want to offer any other kind of program, don't add a line item to the receipt. It's a bad idea. It's a red flag to Visa, and they are all over it. If you're an ISO and you're still doing that, you are literally asking for fines. And trust me when I tell you that over the next 24 months, the enforcement around those programs is going to get much, much worse as Visa uses their new 3% cap to much more easily identify what they consider non-compliant surcharging. Number two, add an addendum to your merchant agreement that stipulates what is compliant and puts the burden of maintaining compliance with shelf pricing, menu pricing, etc. on the merchant, not on you. This is so important. Now, does that mean we're doing it because we want to abandon our merchants and not help them? No. But what happens is it allows us to have some leverage so that when Visa reaches out, you can say, look, the merchant signed this piece of paper that says we told them what they need to do and that they are responsible for ensuring that they do it. So if you have a problem, reach out to the merchant. Don't reach out to us about their menu price or their shelf price. Obviously, we're still going to then help the merchant, but Visa has much less of an appetite to go directly after small business owners with fines. They would much rather fine you, the ISO or the acquirer. Next, I would recommend that you agree with Visa about the menu and the shelf price. Let's just say short term, we lost that battle. Again, you know what I'm saying? Long term, I'm all about the free speech. I'm all about the merchant being able to do whatever they want in their own business. But short term, the right strategy here is to say, we lost that battle. So when Visa reaches out and says, hey, this merchant, the shelf pricing, the menu pricing is not right, you respond with, we agree with you, Visa. Okay. However, that's not our problem. We have reached out to the merchant. We have the signed addendum that they agree that this is what needs to be done. We are doing everything we can do, but we don't print menus and we don't print labels. So this is on the business owner, not on us. And again, Visa is much less capable of going after one small business owner at a time to enforce these rules and fine those business owners. We're still going to help the business owner, but we need a little bit of leverage so we can work on it. Finally, and this is a tough one, but you have to cancel or reverse back to Interchange Plus on non-compliant merchants. I know this is tough. Nobody wants to hear this right now, but it's, 1 out of 100, maybe 1 out of 300 merchants where we're getting all the way to we're about to be fined. What you have to do is you got to reach out and get them onto a compliant surcharge program and say you have that option, or you can go to Interchange Plus, or you can go to another processor. But you just can't afford the liability of that. And so don't be surprised when that's what your ISO or processor ends up doing, because they're not going to pay $5,000, $10,000 per merchant just so that they can stand up to Visa short term when nobody else is joining them. In addition to this video, if you text me on the number that you'll see here on the screen and just text and say compliance, I will send you back a link to a PDF document that outlines this in more detail so you can share it with those people on your team that need to get a deeper understanding of this particular issue, and so that I can put a little bit more info in there than I can in a quick video like this one. My name is James Shepard. I wish you fantastic success. I love these programs. I want to protect these programs. I'm going to do whatever I can behind the scenes to get things moving. But on your side, I would highly advise you take these short-term action steps that I've outlined just to keep yourself compliant and not put you in a situation where you owe a bunch of money.